Alan Gassman, and I am so appreciative of having Colleen Flynn here with us today. Colleen is a fantastic employment law specialist. She's fantastic not only because of her knowledge and her presentation skills, but also because she's really, really good at explaining these rules to clients and handling employment matters without making them worse than they have to be. So sometimes I'm even happy when clients have employment problems, so I get to work with Colleen. Colleen, welcome.
Thanks. Thanks, Alan.
So
How are
Colleen,
you holding up?
I'm holding up great. As you know, I'm doing a voluntary confinement here to a rental house because Marcia and I just got back from a trip to Santiago, Chile on vacation. So I'm getting a lot more work done than I ever got done in my office. My staff is holding up very well. More people are working from home, just like you're working from home. So
Yep.
These are your slides. Why don't you take us through these and let us know what we need to know from a very practical standpoint about what the heck to do during this crisis.
Sure. So the past week, life as we know it as Americans and as employers has changed dramatically. And so over the weekend, the House passed a bill that's the Families First Coronavirus Response Act. And so many of you probably saw articles that came out Monday that were outlining the leave available paid for employees. Well, when that bill was sent to the Senate made some significant changes to it. As a result of the changes to it, it will cost employers less, arguably, possibly will cost nothing if you get all the tax credits that we believe will be coming, but it will not apply in quite as many circumstances. So please bear in mind, President Trump just signed this less than 18 hours ago from when we record this seminar. There are no regulations yet interpreting this act. And so as many of you know, in employment law, we have the act, and then we have the Code of Federal Regulations, which is where many of the things that we look at when we're dealing with employee issues come from. So bear in mind, this is all very, very new. And when you have a particular circumstance that comes up, please reach out to your advisor or your counsel and have them help you through the particular circumstance that you have. So I'm going to give you the basics of this act that has now become a law, and we will all sort of muddle through it together, but these are the things that you need to know. So the Families First Coronavirus Response Act has many different parts to it. The part we're going to focus on these 30 minutes is really the part that affects employers. There is also a part for additional funding for unemployment benefits that will go to the state. How that is going to get to which state is going to be based on the level of unemployment that results. How those funds will be doled out, I do not know. So as of right now, I cannot give you any information that you may be asking me as to how much unemployment will my folks get if I have to lay them off, but there is money allocated for that. But what I do know is that right now, the Families First Coronavirus Response Act has two important provisions for employers. One is the emergency paid sick leave, and then the other is the enhanced FMLA. Typically, many of you who are not covered by the FMLA, and you say, Colleen, I have 25 employees, I'm not covered by FMLA. This covers you. This act covers all employers up to 500 employees. Whatever you think of the public policy decision of saying, why aren't they covering people over 500, whether it's because they believe that they already have sick leave policy or because there's special interests at play, I don't know. I can't comment on it. We can all, discuss that after this passes us. But right now, if you have 2 employees versus 499 employees, you're covered. So the first provision is the emergency paid sick leave. Full-time employees will get 80 hours of paid sick leave. Part-time employees will get the average hours that they worked over the 2-week period that is paid for by you, the employer. Now, we'll talk about this at the end very briefly, but there are supposedly going to be tax credits that will pay you back for the leave that you are paying out to these employees under this. So you will want to make certain from a practical standpoint that your HR department is properly coding these things so that you can get your tax credits at the end of the year. So the employee may first use this paid sick time before using other paid leave. You cannot require the employee to use any other leave first before this. You can't say, oh, you have a bank of PTO waiting for you. No, if their leave is going to be covered under this, they have to be allowed to use this. there's no length of employment. You know, some of you may say to me, Colleen, FMLA, I only have to cover them if they've been here a year, not under this. And note that if they don't use it, it doesn't carry over. They don't get paid out. Should they quit? Or, you know, this is for these circumstances. So if we move on to the next slide, we'll see the reasons why why they could qualify for this. The first is if the employee is subject to a federal, state, or local quarantine order. So if somebody's coming back from China or they've been on a cruise boat that's ordered quarantine, they would get this. The employee's been advised by a healthcare provider to self-quarantine, or the employee is experiencing symptoms of COVID-19. And please forgive the typos, you know, we've only had these in place a couple hours here. So we have 3 reasons, and for those 3 reasons, the employee is entitled to be paid at their regular rate up to a maximum of $511 per day, up to a total of $5,110 for 2 weeks. So that's if you're a full-time employee, that's your maximum. So on to the next slide. We can also be granted leave for this if an employee is caring for an individual subject to the quarantine order, if an employee is caring for a son or daughter, if the school or childcare is closed or unavailable. So many of you are like me, we're working from home, our child is on virtual school right now. If I couldn't work from home and I just had to take off work, as you know, if I were, let's say, a hygienist, like, you know, and need to go to work, then I would be entitled to this leave. Or if the employee is experiencing any other substantially similar condition specified by HHS. Of course, this is very vague, but you know, we're thinking this is flu-like symptoms, something like that, where we don't want to have these people in the workplace because it could be contagious. And for those reasons, the employee is entitled to be paid at their regular rate up to a maximum of $200 per day. So that would be $2,000 for 2 weeks hours on this sick leave. So that's under the emergency sick leave provisions in the Act. So if we move on to the next slide, you will see that we also have the Emergency Family and Medical Leave Act. So this, again, all sizes of employers, even if you have 12 employees, this is going to cover you. The employee who has worked for at least 30 days prior to requesting the leave and they have a qualifying reason. So please know that this emergency family medical leave and the regulations that are going to apply to it only apply to this provision of the leave, leave in the Act. These acts will only apply through the end of 2020 right now. They're not indefinite changes to the law. That's why they're called emergency. And so the regular provisions of the FMLA still apply for everything else. So if you say to me, I'm not usually covered under the FMLA, so what I say to you is that only this covers you. This doesn't bring you into the FMLA for everything else. So in this case, employees are covered if they've worked 30 days and they get up to 12 weeks job protected leave, which is paid after the first 10 days. So it's paid under this Act after the first 10 days. Now, hypothetically, if they haven't used their 2 weeks sick leave under the other portion of the Act, that sick leave will cover the first 10 days, and then this will come into play. So the qualifying reason under this Emergency Family Medical Leave Act is that the employee is unable to work or telework due to the need for leave to care for their son or daughter under 18 years old, if the school or place of care has been closed or the child care provider is unavailable due to public health emergency related to this pandemic. So again, my child's school is closed because of this pandemic. I'm now entitled to this form of leave. And moving on to the next slide, we will see that under this Act, the first 10 days, like we discussed, may be unpaid. So let's say I already used my 10 days of emergency sick leave. Let's say I was sick or I had symptoms and I don't have it. Then the first 10 days are unpaid, but I could use my PTO, or down here they're saying, oh, look, you could use your other 10 days or your first 80 hours. We cannot force employees to use paid leave in this way. So if they say, I want to save my emergency sick leave in the event that I get the coronavirus, and I want to use those 10 days unpaid and use my PTO for them, that's fine. But likewise, we can't force them to use their PTO in lieu of this. And so after the first 10 days, the employee must be paid at 2/3 of their regular rate. So this is only 2/3. And pay is capped at $200 per day and $10,000 in the aggregate over the full 10 weeks. So those are really the issues that I've been getting all sorts of calls over the past couple days on this. And really, it's only been this morning that we can even tell you what happened, because it wasn't until yesterday that the Senate voted on a significantly different version than the House voted on over the weekend. So now that we know this, that is currently what is in effect. And so
okay, so
you have people, yes.
Let's go back to the first slide.
Okay.
Because I think you've done a really good job of explaining this. But could you now explain it in the language that a worker would understand, what their rights are under these new laws? Really simplify it so that we just hear it all one more time.
Yes. So pretend it's me. Okay, Alan, I'm your legal assistant. I come to you and I say, my daughter's school is closed. I can't work remotely. I don't have that capability for whatever reason. I just need to go home and supervise her studies. Her school's closed. So for my first 2 weeks, I'm going to use the emergency paid sick leave that we first talked about. So for my first 2 weeks, now we're going to go on to the second slide, the next one.
So that first 2 weeks, I have to pay it, but I might get a credit for it later.
Yeah. And so if we move, because I am going for my daughter, I'm covered by the third slide. Let's move to the next slide. And you will see, because I am out these first 2 weeks caring for my daughter because her school's closed, I will get paid my regular rate for this up to a maximum of $200. Okay. But school's not reopening. So now, after the end of those 2 weeks, Colleen is going to move into the next slide, the emergency family leave slide. So now I still have 10 more weeks available to me to take care of the schooling and supervising since the school is closed. And so now, under this portion of the act, if we move on to the next slide, we'll see that I am entitled to be paid $200 per day. That's 2/3 of my regular rate. I get 2/3 of my regular rate. If my regular rate is only $150 a day, all I get is $150. But if my rate is $500 a day, I'm only going to get 2/3 of that, but it's going to be capped at $200. So the most you would pay me is $200 per day for the remaining 10 weeks. And you want to properly code that so that you can hypothetically get your tax credits at the end of the year that are supposedly going to occur. So that's how you would handle it. Another scenario would be, let's say I get the coronavirus and I need to, or how about this? I come back from a cruise and I'm told to self-quarantine for 2 weeks. So that falls under the first 2 weeks, but I get paid my full rate up to the $511 a day for those first 2 weeks. And guess what? Now that I get out of quarantine, oh no, my daughter's school's closed. So now I'm falling under this next portion of the act for my 12 weeks, but I'm going to have 10 weeks of paid available because my first 2 weeks are going to be unpaid since I already used up my sick leave. So it's, you know.
Now, if you're quarantined if you're quarantined but you're able to work, and the employer provides you with a computer, then you have to work.
Well, an employer can't really, force you to work if you're sick enough to not work. I mean, if you can work, I think the best thing is to allow employees to telework to continue that, the camaraderie of work.
Right, because most people quarantine from a cruise are able to work. They're not sick.
Yeah,
they may be a little hungover, but they can still work.
Right.
Now, what about when the governor orders you to only have 50% of your staff in the office? The other 50% have to go home, and then can you make them work if you send a computer with them, or if you can't get them a computer, then you have to follow these rules, I guess, as if they were quarantined?
No, because they're not really quarantined. They're not being quarantined. They're just social distance. So, all of this is very new, but my reading of it is that at this point, they can go telework, and then if they don't have telework for them, then you reduce their hours, and that would arguably bring them under the purview of unemployment for the reduction of the hours. And they would want to apply for unemployment benefits if you have to reduce their hours. But it's not technically a quarantine.
And then here's something I'm sure all the lawyers in the audience want to know. Is there an attorney fee provision so when the ambulance chasers of the world start representing their cousins and file a lawsuit because you accidentally missed the day, do you have to pay the attorney's fees on top of that?
Well, there is a provision in there about enforcement, and that if you don't do the sick leave, it can be a violation of the Fair Labor Standards Act. So that would be a prevailing party's attorney's fees. But we're not quite certain how that's going to be enforced yet. So we're going to wait till the regulations come out to comment on that.
Okay. All right. Beautiful. So sorry to interrupt you, but I think it's very well explained.
Yeah, we're trying. I mean, we're digesting it and trying to keep everybody abreast of it. I think that the larger issue is going to be all of the layoffs that are going to occur, or the reduction in hours that are going to occur just because of the lack of work during this period. So that's really a different issue. Well, the compensation will, arguably come out of the unemployment comp funds, because you can apply for unemployment due to a reduction in hours, and depending on what this emergency funding does to for us in Florida, what it will do to our fund and how they will administer it remains to be seen. But even under normal times, if you go from a 40-hour a week and your employer says they only have 10 hours a week for you, you are entitled to a certain amount of benefit.
From the employer or from unemployment?
Well, from unemployment.
Right.
Which will impact the tax rate. Yeah, I mean, and I don't know what the state will do, if they will say during the pandemic, we're not going to count the unemployment claims against your tax basis, because as you know, the more unemployment claims you have, the higher your tax rate.
Right. So the employee that's out on the cruise, can I terminate her before she comes back, and then she's not entitled to that pay? Or the employee who I terminate on Monday and she gets symptoms on Tuesday?
Well, I think you're looking at a couple issues, and we can't retaliate against people who need the leave under that. I mean, that's clear. There is an anti-retaliation provision. So if you're terminating somebody to avoid giving them the benefits under this act, that would, in my opinion, be retaliation. And quite honestly, we're going to be getting tax benefits from it, so it shouldn't be quite as detrimental financially. And there are supposedly going to be some provisions from the IRS for people who are having cash flow issues caused by this. But I think that, if you're having a layoff and you say, listen, anybody who, everybody but 5 people are getting laid off, and that person on the cruise is one of them, that's not retaliation. Now, if you say, I'm firing her before she gets back because she's going to have to go in quarantine, I'm going to have to pay her, I think that could be deemed retaliation.
Okay. Can I prevent my employees from going on cruises? Because the cruises are still for sale.
Cruises are closed. I think at this point, right now, I don't think anybody's getting on a cruise, but we talked before this became so serious about employees who had vacations planned to certain places, and could we prevent them from going? And it's hard to prevent off-duty behavior, but if they're ordered to quarantine, they're ordered to quarantine. Or if they come back with symptoms, it is what it is. So I think that, we strongly recommend employees don't do things that would put themselves at risk, because they are going to have to quarantine under certain circumstances, and then they can't come back to work until they've, passed the quarantine.
Now, how about individuals who are employed as independent contractors, if you're giving them a 1099? Okay.
Independent contractors are not covered, only employees.
And does the law say an individual who's actually an independent contractor, or an individual who has been traditionally paid as an independent contractor?
Well,
you didn't see any from the legislation about that.
It just says it only applies to employees. So that's for those plaintiff lawyers who are going to say, you misclassified me as a contractor. I should have been classified as an employee, and therefore I should have been entitled to these benefits.
Do you think there's going to be any issues where people get sick because they caught it at the office and that it'll be covered under workers' comp versus medical insurance?
I think that's a great question, because I've had that come up. People have said, well, what if I get it in the workplace? Is it going to be work comp? And my answer is, occupational injury or sickness, things like that, those are typically covered under work comp, but I don't know how this would be an occupational illness. And I also don't believe that we're going to keep tracing and ever be able to tell where people got it at certain points. And so I think it's unlikely that it's going to fall under work comp. I think it's going to be under health insurance, but that remains to be seen, and it may be different for first responders or healthcare workers rather than someone like you or I who work in the traditional business setting.
Right. Okay, I'll stop interrupting you now. What slide are we going to?
We can go to the next one, and some of these are just some guidance we've gotten guidance from the ADA, we've gotten some guidance from OSHA, there is an EEOC pandemic preparedness in the workplace, and the Americans with Disabilities Act handout, and who knew this, and the EEOC has been relying heavily on it the past few days. And so these are some of the, just questions that the EEOC has answered, and from their perspective, with the ADA, and because, obviously, since this is a medical condition, it implicates the ADA. So typically, we can't ask employees too much about their medical conditions. We have to be real careful about that. However, their guidance is basically saying that during a pandemic, you can ask employees if they're experiencing symptoms of the virus. So, shortness of breath, fever, sore throat, and, you must maintain the all information, pretty confidentially. I think confidentially got caught up there. So you can't go around and say, well, Colleen's not in the workplace because, this, that, and the other thing. I mean, unless it becomes a public health issue, and then that's a different scenario. We would have to work in concert with the health department if somebody in our workplace did come down with it. But you are as the employer able to ask people about that. So
okay.
Next slide, please. Can you take the temperature? That was a question that I actually got asked, and that the EEOC has answered. Now, generally, that's a medical exam. You need to, have written consent, and everybody agrees to it. You keep it confidential. But because the CDC and the health authorities have acknowledged community spread, employers may measure the employee's body temperature. However, what the EEOC is saying, that you need to be aware that some people may not have a fever, so it may not be foolproof, and it may not be exactly what you want to do. But taking people's temperature is going to be okay under these circumstances.
Okay.
So you can send people home. Next question. You can send people home. They are showing symptoms. Could be symptoms of the flu. Could be symptoms of something else. But we don't know. And so you can send these people out of the workplace. Now, again, remember what we talked about earlier under the emergency leave, the emergency sick leave. If they're showing symptoms and trying to get to the doctor and whatnot, that's going to be covered leave, and so you're going to become obligated to pay that. But they 100% should leave the workplace.
Colleen, what about an employee? What about an employee who maybe is older or unhealthy, and there's a concern that employee, if they catch it, could die? Can you force that employee to work from home, or treat that employee differently against their will?
Well, here's the thing. I think that under these circumstances, it's kind of the reverse question, Alan, that I've been getting, which is so-and-so wants to work from home. They say they have an underlying medical condition. They're concerned to being out in public. The answer then is, of course, that's an accommodation under the ADA, because if they have, let's say Parkinson's or MS or diabetes, anything that could make them more susceptible, we should accommodate them and send them home. Now, we also do as employers, if we're going to institute social distancing, then maybe we say, listen, we're social distancing our workplace, and anybody who meets these heightened criteria, we're going to send you home to social distance everybody. We want to make certain that, it's not necessarily just discriminatory, but under these circumstances, I don't think anybody is going to, bring a lawsuit or say, you social distance me because of my disability. I think the issue is we're separating the workplace. We need fewer bodies in this building, and we're trying to keep the people who are most at risk, away from germs.
Perfect. Okay. Thank you very much.
Sure, let's go on to the next slide, please. Do we have any more, or is that the last of the slides? That may be the last of the slides we put on there today. So the couple other things I wanted to talk about just in the last few minutes here is, we've gotten a lot of questions about furloughs and layoffs and how do I do this and what do I do? And I don't want to fire people, but I also can't keep everybody in the same situation. So we've done other seminars together where we've talked about how you pay people and whether you pay them as exempt employees or non-exempt employees under the Fair Labor Standards Act. So the caution that I want to give everybody is reducing hours of people. If people are non-exempt employees and they're paid hourly, you can go ahead and reduce their hours because legally we only pay them for every hour worked. If they are exempt employees paid a salary, remember, if they work 5 minutes in a work week, whatever your 7-day work week is, they have to get their whole salary. So you can't say from now on, I'm going to just, reduce your salary. And, this week I'm going to have you here 3 days, so I'll reduce it to 60%. Next week I'll have you here 4 days, I'll pay you 80, because that violates the exemption. If you're in, let's say, the hospitality industry where you really can't keep these managers on, these exempt managerial employees who might be making significant salaries, then for the next couple months, you're going to just have to say to them, we're converting you to an hourly manager, because you can always pay people who meet the duties test on an hourly basis. So what you can do is just say, we're not going to have a lot of work because we're not going to have any visitors to Pinellas County, Florida. So you, who I used to pay you, let's say $1,500 a week in salary, I'm going to convert you to an hourly employee and pay you X dollars an hour for the hours that you work. And if you have any bank PTO, you can feel free to use it to make up the hours to 40, or you can file for, some unemployment benefits depending on what the decrease in hours are. So just be careful if you're going to be an employer who's going to reduce time worked by exempt employees, because that's where sometimes people get in trouble.
So you need to take those managers, you need to make the managers hourly before they get the virus or before their family gets the virus, right? Because once they announce to you that they're quarantined or they have it, or they have to care for a family member that has it, then you're probably going to get tagged for punishing them by converting them to hourly. Once that happens, right?
Yeah, I guess you might be, but I would think that if it's business reasons, it's not going to be retaliatory. So what we can't do is we can't retaliate because people are exercising their rights to take this leave. But if let's say that I run a big hotel on the beach and I'm the sales manager. Okay, so I'm not going to be doing a lot of sales probably, unfortunately, the next couple months. And so instead of paying me $2,000 a week for my normal, 45 to 60 hours that I work, what you're going to say is, listen, Colleen, I want you to stay, but I can't keep paying you like this, and I don't even have a lot of work for you, so we'll convert you to, some kind of $30 an hour for whatever hours worked. And so if I work 30 hours in a week, I get $900, but then when I work over 40, I would get time and a half. But I think that, the downturn in business is not going to be a problem when you're making changes. What is going to be a problem is if you retaliate against people who exercise their rights. Okay, so just a couple other questions that, we've gotten and that the EEOC is trying to give us some guidance on the EEOC. What do we do about return to work notice? What if, I stay home because I had some symptoms, but really it just turns out it's allergies. And so I've been home for, my 14 days and now I'm ready to come back. Can you ask me for a note? Well, sure. If, I had some pretty serious conditions, but, I think it's going to be really hard right now to provide fitness for duty documentation. So, we're just going to have to play that one by ear and see what we can get, if they can certify that, people don't have it or certify that they're not contagious in the workplace. So while it is permissible, I think we're going to have to exercise some flexibility over the next couple of weeks about what documentation we're looking for. If you're hiring, which, let's be grateful that certain people are hiring, probably grocery stores and maybe hospitals, you can screen applicants for symptoms of it after you make a conditional job offer, as long as you're doing it for everybody else. And so, go ahead and do that. And could you take their temperature as part of a post-op or pre-employment exam? Sure. But again, fever's not the end-all be-all of this disease, so it's not going to be telltale. So those are, really the issues, sort of the issues that have been on fire for the past couple days that we've been talking on the phone nonstop about with people. And as I said earlier, take everything with a grain of salt, call your own legal advisor, because these things are changing by the minute. We don't have any regulations for the Families First Act that went into effect, and so we're waiting for those. And, sometimes the interpretations are different, but at this point, that is what we have. And I think if everybody just tries to, do their best and treat the employees fairly, I think it'll turn out okay. The problem for a lot of people is they are going to have to shut their doors or lay off employees, and that becomes hard. That just becomes hard psychologically on everybody. But hopefully with the enhanced unemployment benefits that are in the Act, it will take some of the sting out of it, and hopefully this won't last as long as some people are predicting.
So based on what we just heard, it's my recommendation that you do speak with an employment law specialist before you renegotiate contractual situations now, so that you are not set up for an attorney's fee clause on the basis that you tried to force the employee to give away some of the rights they just got under this new law. So even if you want to just reduce their hourly rates, reduce their hours, terminate them, it's just not a bad idea to have a 15 or 20-minute conversation with an employment lawyer. Because Colleen and I know that a lot of employers try to do the right thing, but they accidentally do it in a little bit different way. And there's a lot of lawyers out there that then jump on that, file a federal court case, and try to get attorney's fees and costs. So we definitely want to be careful with that. Colleen, I know you're a member of a very large and very successful law firm. Do you have any insights for us as to what your firm is doing in particular, or what you've seen anyone doing in particular that you really like or that you really don't like?
Well, we are doing our best to make certain that if everyone has to go remote, that we have capabilities to do that. And Alan, I know your firm is also very technologically advanced. Ours, we have the capability, but so many of us have worked there so long that we like going to work. And I like going to the office. So this week has definitely been an adjustment for me. However, we have so far been successful at getting everybody who's tried it to work remotely. So I would advise everybody to do a test run. So, test run by groups if you have to, see how you can do it, see what the pitfalls are. If everybody has to go remote, I think also I've heard, in other states, I think it's New York that I just heard, Governor Cuomo is requiring that only 50% of the workplace be present. I personally think that's a good idea, reduce face-to-face contact, reduce the spreading of germs. I for one, am happy to go in at 6:30 in the morning and, full shifts if we need to on bodies in the office. So, there's lots of things you can do. Yeah, there's lots of things you can do for social distancing. It's some industries, obviously, you can't work from home, and those are really the industries and the employees who are going to suffer.
Yeah, that's a very, very good idea. By the way, typically when you work from home, when you want to access your computer at the office from home, you would pay GoToMyPC $600 a year. But our IT person found the equivalent service for $200 a year per computer. So if anybody wants a reference to that company, just send me an email. Colleen, why don't you give us your email address so people can bother you with emails?
Sure. It's Colleen, my first name, 2 L's and 2 E's, my last initial S as in Frank, at jpfirm.com. And you can call me there, or I will give you my phone number, and my receptionist will put you through, and you can leave me a voicemail because I'm probably already on the phone, and then I will call you back. My phone number is 727-461-1818.
And for clients of my firm, we often will pay Colleen's firm directly, which prevents her from having to open up an account and get a retainer from you and that type of thing. But it's real important, if you call Colleen and it involves another person that may sue you, you have to tell her very explicitly who that other person is to make sure that there's no conflict of interest. Well, Colleen, I'm sure we're going to be doing more of these. Go ahead.
Yeah. No, I was just going to say, and general advice obviously is a little different than when you want to call me and tell me about a specific employee's needs. But if you need general information on this, just feel free to call me, and either myself or my associate will be happy to help you.
And then Colleen will bill me. I'll bill to the client. There's no middleman here. We just pass it through for convenience. All right. Well, Colleen, thank you so much. I really, really appreciate it. And I know one person who's really happy about this virus, and it's your dog, because you're home with your dog.
My dog.
I see you.
Right here. Yeah,
I saw you were holding your dog. I love it.
Yes, I'm holding my dog, and my daughter, who is 11, is building the Las Vegas skyline in Legos right now. So we're all trying to be as productive as possible.
Perfect. Okay. Well, thanks a lot, and may the rest of everybody's day be billable. Thanks a lot. Take care.
All right. Thanks. Bye-bye.
Bye.